There is a federal law that gives you up to 60 days to dispute any unauthorized charge on a credit card and forces the bank to investigate on your behalf, freeze the merchant's funds, and provisionally restore your money while the investigation proceeds. The bank bears the risk. The merchant bears the burden of proof. And you, the consumer, sit protected behind a wall of liability that costs you nothing to access. The maximum you can ever lose on a fraudulent credit card charge under federal law is $50. In practice, the major card networks have voluntarily reduced that to zero. Every dollar a fraudster spends on your credit card can be recovered. Every unauthorized transaction can be reversed. The bank's money is at risk, not yours. And the bank, because it is the bank's money, will investigate with a ferocity and a legal infrastructure that no individual consumer could ever replicate on their own. Now consider what happens when the same transaction occurs on a debit card. The money leaves your checking account immediately. It is gone. Your actual cash, your mortgage payment, your grocery money, your emergency fund. And under the Electronic Fund Transfer Act, your liability window is 20 times smaller and your recovery window is far less forgiving. If you report the fraud within 2 days, your liability is capped at $50. If you wait more than 2 days but fewer than 60 days after your statement, your liability jumps to $500. If you wait more than 60 days after the statement is mailed, you could lose everything that was taken. And even if you report promptly, the bank has 10 business days to investigate before provisionally restoring your money. 10 days during which your rent check may bounce, your automatic payments may fail, and your credit score may be damaged. Welcome to the Invisible Ledger. If these stories matter to you, hit subscribe and the bell. This is where we trace the money they told you not to follow. The legal framework for credit card protection traces to the Fair Credit Billing Act of 1974, signed by President Gerald Ford and codified at 15 U.S.C. sections 1666 through 16666J. The FCBA was enacted in response to widespread consumer complaints about billing errors, unauthorized charges, and the near impossibility of resolving disputes with large creditors. Before 1974, if a merchant charged you for something you did not receive or a fraudster used your card number, your only recourse was to sue in court. The FCBA created an administrative dispute process that required creditors to investigate and respond to billing errors within a specified time frame, and it limited consumer liability for unauthorized use to $50. The mechanism of the chargeback, the formal process by which a consumer dispute results in the reversal of a credit card transaction, was developed and operationalized by the card networks, primarily Visa, MasterCard, and American Express, building on the FCBA framework. The chargeback system created a contractual obligation between merchants and acquiring banks. When a merchant accepts a credit card payment, they agree to the card network's rules, which include the obligation to respond to chargebacks within specified time frames and to bear the cost of transactions that are successfully disputed. A merchant who loses a chargeback not only refunds the transaction, but often pays an additional chargeback fee ranging from $15 to $100. Multiple chargebacks can result in a merchant losing their ability to accept card payments entirely. The practical result is that the credit card dispute system is one of the most consumer protective financial mechanisms in American law. Under Regulation Z, which implements the Truth in Lending Act and incorporates the FCBA provisions, a credit card holder can dispute a billing error, including unauthorized charges, goods not received, goods not as described, and certain other categories, by notifying the card issuer in writing within 60 days of the statement on which the charge appears. The issuer must acknowledge the dispute within 30 days and resolve it within 90 days or 2 complete billing cycles, whichever is less. During the dispute period, the issuer cannot charge interest on the disputed amount, cannot report it to credit bureaus as delinquent, and cannot take legal action to collect it. Before I go further, this video is just the surface. Inside the Invisible Ledger Vault, you will find the complete chargeback filing guide with reason codes for Visa, MasterCard, and American Express, the FCBA dispute letter template, the Electronic Fund Transfer Act comparison chart, and the 12 additional consumer protections embedded in Regulation Z that most cardholders never use. The link is in the description, but stay right here. The debit card framework tells a dramatically different story. The Electronic Fund Transfer Act of 1978, codified at 15 U.S.C. Chapter 41, Subchapter 6, and its implementing regulation, Regulation E, governs electronic fund transfers, including debit card transactions. The protections are structurally weaker than those under the FCBA in several critical ways. Under Regulation E, liability limits are time-dependent and fault-sensitive. The 2-day and 60-day windows create a liability structure that punishes consumers who do not monitor their accounts obsessively. In contrast, the FCBA's $50 maximum applies regardless of how quickly you discover the fraud, because the credit card transaction uses the bank's money, not yours. More fundamentally, debit card fraud exposes your actual bank balance to the fraudster's activity immediately. When a fraudster uses your credit card, They are spending the bank's credit line. The bank is out the money, not you. The bank's financial interest in recovering that money is aligned with yours. When a fraudster uses your debit card, they are spending your checking account balance. The money is gone the moment the transaction clears. And while the bank may investigate and restore the funds eventually can mean days or weeks, during which your financial life can be significantly disrupted. The banking industry has a vested interest in debit card usage that is rarely discussed. When you use a debit card, the interchange fee paid by the merchant to the card network and the issuing bank is significantly lower than on a credit card, primarily due to the Durbin Amendment to the Dodd-Frank Act of 2010, which capped debit interchange fees for banks with over $10 billion in assets at approximately 21 cents per transaction. Credit card interchange is not similarly capped and typically ranges from 1.5 to 3% of the transaction amount. For the bank, a debit card transaction is less profitable than a credit card transaction, but the debit card is marketed as the responsible choice, the one that keeps you from overspending, the one that is linked to your actual money. The messaging serves the bank's interest in maintaining checking account balances, while encouraging consumers to use the card format that generates the most data and the most fee revenue from overdraft charges when balances run low. According to the Federal Reserve's 2022 Diary of Consumer Payment Choice, debit cards account for approximately 28% of all payments in the United States. Cash accounts for 18%. Credit cards account for 31%. Among lower and middle-income consumers, debit card usage is significantly higher. The consumers with the least financial cushion to absorb fraud losses are the ones most likely to be using the payment instrument with the weakest fraud protection. If you have made it this far, you already understand the liability asymmetry between credit and debit better than the majority of Americans who hand a debit card to a cashier every day without considering what they are exposing. Subscribe and share this video. Now let me give you the exact framework. Step 1. For all discretionary purchases, especially online, use a credit card, not a debit card. The FCBA's $50 maximum liability and $0 liability in practice from major networks make it the structurally safer payment instrument for any transaction where fraud is possible. Step 2. If you prefer to control spending and avoid credit card debt, use the credit card as a charge card. Charge purchases to the card and pay the full balance every month before interest accrues. You get the consumer protections of a credit card with none of the interest cost. Step 3. Keep your debit card in a safe location and use it only for specific controlled transactions, such as ATM cash withdrawals from your bank's own machines, where fraud risk is lower. Do not use your debit card for online purchases, at gas pump card readers, which are a common skimmer target, or at unfamiliar retail locations. Step 4. If you experience fraud on a credit card, call the number on the back of your card immediately. State that you are disputing unauthorized charges and request a chargeback under the Fair Credit Billing Act. Your liability is limited to $50 and in practice to $0. Step 5. If you experience fraud on a debit card, call within 2 business days to limit liability to $50. File the dispute under Regulation E. Ask for provisional credit while the investigation proceeds. Document everything in writing and send a follow-up written dispute letter. Step 6. Monitor both accounts through your bank's mobile app with transaction notifications enabled. Catching fraud within hours of occurrence gives you the strongest possible position under both the FCBA and Regulation E. I need to be honest with you. Credit cards are not risk-free, and there are real limitations to consider. First, credit card debt is one of the most destructive financial forces affecting American households. If carrying a monthly balance, the average credit card interest rate of over 22% in 2024 can easily cost more than any fraud protection benefit provides. The strategy only works financially if you pay the full balance every month. Second, credit card rewards programs, which are often cited as an additional reason to use credit cards, are partially funded by merchant interchange fees, which are ultimately passed to consumers through higher prices. The benefit is partially illusory at the macroeconomic level, though real at the individual level. Third, chargeback abuse, disputing legitimate transactions to avoid paying for goods or services, is fraud and carries legal consequences. The FCBA and chargeback system are designed for genuine disputes, not as a mechanism to obtain goods for free. Fourth, some merchants charge a surcharge for credit card use, which in many states is now legal following a 2013 settlement in the payment industry. Where surcharges are applied, the economics of credit versus debit change. And fifth, prepaid debit cards issued by the major networks have some but not all of the protections of bank credit cards. Their protection framework is closer to debit than to credit. Always verify the specific protections on any prepaid card before using it for large purchases. Your grandparents kept their money in their pockets, in mason jars, or in savings books at banks where they knew the tellers by name. Every transaction was deliberate. Every payment was visible. Then one generation was handed a piece of plastic and told it was the modern way. Two pieces of plastic that look identical, feel identical, and are accepted at the same terminals, but that exist in completely different legal universes the moment something goes wrong. One piece of plastic puts the bank's money at risk, the other puts yours. They never made sure you knew the difference. There was not a more transparent system. There was just one where you had to ask the question no one thought to ask. Subscribe and share this video. Every share moves one more consumer from the weaker card to the stronger one before their next fraudulent transaction. The next vault opens soon, and what is inside will reveal a secret blacklist that banks use to deny account applications that most consumers have never heard of and that a federal law gives you the right to erase.